decision in common and march in a cooperative way on that road which is bound to lead us to unity.
August 15th, 1947 seems like a long time ago. It indeed was. A 7.5 decade is a long period of time, though it is but a fleeting moment in the history of nations. The world was different then. India was different then. Namaskar, hello and a very warm welcome viewers. You're watching the special presentation of Sansad TV, The Amendments. As we celebrate Azadi Ka Amrit Mahotsav, marking 75 years of independence, we need to pause and reflect upon the landmark amendments to the Constitution that have shaped our country. These amendments highlight the transformation of the economy from agriculture to services, from shortages to surpluses, from basic survival to global goals. So get ready for the speed ride. A distinctive document with many extraordinary features, the Constitution of India is the longest written constitution of any sovereign nation in the world. The original text of the Constitution contained 395 articles in 22 parts and 8 schedules. It came into effect on January 26, 1950, the day that India celebrates each year as the Republic Day. A constitution designed to keep the country together and to take it forward had necessarily to be an elaborate, carefully worked out and painstakingly drafted document. For one thing, it sought to heal the wounds of the past and the present, to make Indians of different classes, castes and communities come together in a shared political experiment. For another, it sought to nurture democratic institutions in what had long been a culture of hierarchy and deference. The Constitution of India was framed between December 1946 and November 1949. During this time, its drafts were well discussed, clause by clause, in the Constituent Assembly of India. In all, the Assembly held 11 sessions with sittings spread over 165 days. In between the sessions, the work of revising and refining the drafts was carried out by various committees and subcommittees. The Indian Constitution was enforced in 1950, and in the very next year, an amendment was introduced. The Act amended the Indian Constitution even before the first elections were held in independent India. There were 3 fundamental changes made in the Constitution through its amendment. It gave ways to limit freedom of speech and expression, supported measures to abolish zamindari, and made it clear that the right to equality does not preclude passing laws that give particular consideration to society's most vulnerable groups. The Constitution First Amendment Bill 1951 was introduced in Parliament provisional on 12th of May 1951. The bill sought to amend Articles 15, 19, 85, 87, 174, 176, 341, 342, 372 and 376 of the Constitution. It also inserted new articles 31A, 31B and 9th schedule to the Constitution. On a motion moved in the House on 6th of May and adopted on 18th of May 1951, the bill was referred to a select committee. The report of the select committee was presented to the House on May 25, 1951. The committee suggested amendments in some of the clauses of the bill as introduced in the House. The bill was reported by the Select Committee and was considered by the House on 29th, 30th and 31st May and 1st and 2nd June, with some modifications, and it was passed on 2nd of June 1951. The first amendment to the Indian Constitution was unique as it was enacted by the interim government. The Constitution First Amendment Act 1951 was passed to remove various difficulties which originated due to Supreme Court's decision in various cases such as the Ramesh Thapar case. The Supreme Court in the case of Ramesh Thapar versus State of Madras struck down the provisions of the Madras Maintenance of Public Order Act 1949 on the grounds that it violated fundamental right to freedom of speech and expression provided in Part 3 of the Constitution. Also in the case of Brijbhushan versus State of Delhi, the Supreme Court struck down the provisions of the East Punjab Public Safety Act 1949 as it was violative of the fundamental right of freedom of speech and expression. The Constitution First Amendment Act of 1951 imposed limitations on the freedom of speech and expression guaranteed under Article 19 of the Indian Constitution. Article 19 was amended for adding 3 grounds of restrictions on freedom of speech and expression based on friendly relations with a foreign state, public order, and incitement to an offence. The amendment paved way for reservation in India to mitigate lost opportunities due to the practice of caste discrimination in India. The reservations are a part of India's affirmative action initiative after independence that assured scheduled castes, scheduled tribes, and other backward classes representation in key areas like education or government employment. The Constitution First Amendment Act of 1951 gives powers to the states to make special provisions for the advancement of socially and economically backward classes. Article 15 was amended by the virtue of Constitution First Amendment Act of 1951 and Clause 4 was added to the Article 15, which allowed the state to make reservations for the scheduled castes and scheduled tribes in educational institutions. Reservations were put in place in Indian Constitution immediately after independence as means to recognize the historical injustice meted out to the people belonging to backward groups and to implement provisions by which they would have better access to resources and opportunities. Reservations in India were introduced to rectify the past and historical injustice against the backward classes, to ensure equal representation, and to provide an equal platform for everyone, irrespective of their caste, and to promote and advance the backward classes.
A clause was added to Article 15, Clause 4, which provided that the government can make special provision in favor of any socially and educationally backward classes of citizens or for scheduled castes and scheduled tribe. Now, question arises why the necessity arose to make this kind of amendment. We have to look this amendment in the context of Article 14, 15 and 16 of the Constitution, because all these 3 articles deal with right to equality, which is enshrined in the preamble of the Constitution itself. Preamble talks of justice, social, economic and political, also talks about equality of status and of opportunity. But this cannot be achieved unless you carry out the principles as enshrined in Part 4 of the Constitution dealing with directive principles of state policy. Therefore, Article 14 was extended further by Article 15 and 16, where Article 15 prohibits discrimination on the ground of religion, race, caste, sex or place of birth, and Article 16 provides for equality of opportunity in public employment. While framing Article 15, the Constituent Assembly made a special provision that for women and children an exception can be created. However, similar kind of exception was not created for the socially and educationally backward classes and for the scheduled caste and scheduled tribes. And if they have to be brought at par with other people in the society, then probably the similar kind of status which was given to the women and children for making a special laws for them was required to be made for the socially and educational backward classes as well as for scheduled caste and scheduled tribe. To achieve this objective and to give effect to the preamble of the Constitution as well as the directive principle of state policy, as exception was created by adding clause 4 to Article 15, which said that government can make special provision in favor of any socially and educationally backward classes of citizens or for scheduled caste and scheduled tribes. I make it very clear that so far as the implementation of directive principle is concerned, we know that even that implementation has to be done in accordance with and protecting the fundamental rights of the individual. Therefore, unless an exception is created in the article of fundamental right itself, probably this kind of law or executive order could not have been passed by the state government. So I think this was a very good amendment made at that time, because of which enabled the government to make policy to protect the interest of the women, children, as well as socially and educational backward classes.
The Constitution First Amendment Act 1951 added 9th schedule to Indian Constitution. Laws contained in the 9th schedule are immune from judicial review. The 9th schedule was created by insertion of Articles 31A and Article 31B. Article 31A was inserted by the government in order to protect laws related to agrarian reform and for abolishing the zamindari system. Article 31B of the Constitution of India provided that any law in 9th schedule could not be challenged in courts. The other feature of Article 31B is that it is retrospective in nature. That is, when a law is declared unconstitutional by a court and later it is included in the 9th schedule, it is to be considered as having been that schedule from its commencement. Thus, it provides blanket protection to all laws under the 9th schedule.
After the Indian independence, when land reforms were being brought about and the zamindari system was being abolished, at that point of time, the Patna High Court struck down the Bihar Land Reforms Act 1950. By doing so, it led to a deathly blow on the idea of land reforms and for later on, of course, abolition of the zamindari system. This was actually very precarious because despite the country wanting to move forward because of judicial scrutiny and judicial review, the laws of this country were unable to take off. Now, this actually troubled the leaders of then, and at that point of time, the fathers of the Constitution who actually thought about how do we really build this Constitution forward were thinking about a way by which they could actually ensure that such laws that bring about land reforms are protected from judicial scrutiny. And therefore came the first Constitution Amendment in the year 1951. So the Constitution Amendment of 1951, also known as the First Amendment, brought and inserted Article 31B. And this Article 31B was introduced to actually introduce the 9th schedule into the Indian Constitution. What was the need of this Article 31B? This Article 31B provided that there were certain laws that are belonging to the center and the state that should be protected from judicial scrutiny and judicial review, and therefore such laws must be placed under the 9th schedule. And therefore the Bihar Land Reforms Act of 1950, along with many such land reform acts, were placed under the Schedule 9. And this 9th schedule ensured that the courts of the day were not able to strike them down or declare them unconstitutional, and therefore the country could progress further through governance in this process. One of the key areas of the 9th schedule is presently, as on date, 284 laws of the country are actually protected under the 9th schedule, which means that the laws made by the parliament cannot be brought under judicial scrutiny, review by the Supreme Court or any courts of the land. Of course, there have been different judgments by the Supreme Court, including the Keshwanand Bharti case, in which the basic structure of the Constitution and the idea behind it was also discussed. But as a parliamentarian, when we think about making a law, there are many times we see that the honorable courts strike them down, especially the Supreme Court. But the 9th schedule ensures that those laws that are brought about by the parliament are provided reasonable safeguards and protection under the 9th schedule. And therefore, in the greater goodness of the nation, it is necessary that certain laws stay protected.
The Constitution First Amendment Act of 1951 also provided that state trading and nationalization of any trade or business by the state is not violative of the right of trade or business if it is in accordance with the conditions that they are in the interest of state security, amicable relations with foreign states, public order, contempt of court, incitement to commit an offence or defamation. Article 87 of the Constitution provides two instances when President specially addresses both houses of Parliament. The President of India addresses both the Rajya Sabha and the Lok Sabha members at the beginning of the first session after each general election when the reconstituted lower house meets for the first time. The President also addresses both the houses at the beginning of the first session each year. Each constitution has some technique for alteration whereby the provisions are changed by method of expansion, rectification or revision in order to suit the requirements of the present. The framers of the Indian Constitution were aware that the changes would be needed in Constitution from time to time. Thus, the provisions for the amendment to the Constitution were made in order to defeat the difficulties which may arise in the future. The authors of Constitution wanted to have a flexible Constitution and they wanted to avoid extreme rigidity in the Constitution of India. They wanted to have the Constitution which could develop with the developing nation and which could change with the changing needs of the people. The success of Indian Constitution for a country as diverse and complex as India continues to intrigue, impress and inspire experts around the world. Well, with that, it's a wrap from my side. Thanks for watching and stay tuned to Sansad TV.